So today we're going to talk about the judicial branch, the third branch of government. And I want to start by looking at this image of Lady Justice. This is a symbol of the judicial branch. You see it often in different forms, but this is kind of the standard. And normally if we were together, I would ask you to take a look at this image and just write down 3 things that you notice. So take a look at this image and think about what are some things that you notice about this image. I want to point out to you a couple things actually 3 things that I noticed. The first is that we see the sword that she's carrying, right? And what is the sword a symbol of? Well, the sword is a symbol of power, right? That there is power in the judicial system. It's a symbol of vengeance, that we get revenge, that when somebody wrongs us, we get revenge. It's also, if you notice this sword, it's a double-edged sword. Okay, a double-edged sword means that it's sharp on both sides, so we have both the favorable and the unfavorable aspects to the justice system. Another thing that I notice when I look at this picture is the scales, right? These scales that she's holding. Lady Justice is holding these scales. The symbol of scales basically shows us that the judicial system weighs the evidence. On one side you have the crime that was committed, and then on the other side you have the punishment. So we weigh the evidence, and that the crime and the punishment should balance each other out, right? So the strength of the crime should be the same as the strength as the punishment, or the weight of the punishment. And then the third thing that we look at is the idea that she's blindfolded. Look at that, her eyes are covered. She's blindfolded. Now, what this is supposed to symbolize is the idea that the justice system is objective. That it doesn't matter whether you have a lot of power or no power, whether you have a lot of money, a lot of status, what your race is, what your gender is, how you look or who you are should not matter. That all people should be the same in the eyes of the law. Basically, justice cannot see you, right? Justice can't see you, so all people are treated equally. So this is the symbol that we look at, Lady Justice. The next thing I want to show you is a picture of the Supreme Court building. And this is the Supreme Court building in Washington. And you see that on the front of this building, the slogan says, "Equal justice under the law." Equal justice under the law. Okay? In the middle here, in the center, in the point, you see that the figure is there. This is a symbol of liberty, sitting on the throne. On the left, you see order, and on the right, you see freedom. Right? This is the images. These are the images that are on the top of the Supreme Court building. And we see the image of Lady Justice. This is the ideal, the vision which we would like our justice system to represent. So the question that I have for you is, do these symbols reflect reality? Are the scales actually balanced? Is there equal justice under the law? Is Lady Justice really blindfolded? This is a question, right? My guess is that some of you might want to challenge whether these symbols really do reflect the reality of the justice system here in the United States. And probably others of you would think, no, they're working pretty well and they're accurate. So this is a question, something for us to think about as we're looking at the judicial branch. Now, the judicial branch is described in Article 3 of the Constitution. And I just want to read a couple of lines from Article 3 in the Constitution. Okay? And this is on page 354 of your textbook. And it says this: "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain, and establish. The judges, both supreme and in inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. Okay? Constitution, page 354 of your book. So let's think about that for a second. It says that judicial power of the United States is vested in one Supreme Court. It's placed in one Supreme Court and in other inferior courts to be established by the Congress. And so what we have in 1789 is the Judiciary Act of 1789. The Congress passes a law which basically puts in place the federal court system. And we'll come back to that in a minute. It also said that judges hold office during good behavior. During good behavior. Basically what this means is that the justices serve for life. They have a lifetime tenure. Okay? The idea is that there's no favor and no fear, because also it says they cannot have a reduction in their salary. So if somebody doesn't like a ruling, it's not that, oh, we can change the salary and punish the Supreme Court justices. It doesn't work like that, right? The idea is that we have what we call judicial independence. Judicial independence. That the judicial system is not tied to the electoral system, it is not tied to electoral politics, and it is not tied to public opinion. That's what the Constitution, that's the system that the Constitution set up. We'll see if that's actually the case. Alexander Hamilton, in Federalist number 78, writes about the judicial branch. Okay? And he basically posits that the Supreme Court, the judicial branch, will be what he says the weakest branch and the least dangerous branch. Now he has a couple of reasons for that, and what he said is that the function of the court is, and this is his words, merely judgment. Merely judgment. That they only judge things, right? That they only have the power to resolve disputes in cases that are brought to them, right? The Supreme Court can't go out and say, hey, we see a problem over here, we need to do something about that. No, they need to wait for the people who are having the problem to bring the case to them. So the Supreme Court has to just sit there and wait. Merely judgment. When the Supreme Court does have cases brought to them, they are not supposed to use their own values, their own ideas, their own beliefs. They're simply supposed to apply the Constitution. They're supposed to look at whatever the problem is and say, okay, what does the Constitution say about this? Okay? And then finally, one of the reasons that Hamilton was saying that this branch was the least dangerous or the weakest branch of government is because the court has no way to implement their decisions. They have no way to enforce their decisions. So it is possible for the courts to make a ruling, wonderful, but then somebody else has to carry it out. The court simply cannot do that, right? So this was these were some of the reasons that Hamilton said the weakest, least dangerous branch. And in fact, in the beginning, in the early days of our country, the Supreme Court was held in such low esteem that some people actually refused to serve. When they were nominated to the court, they said no. They did not want to be Supreme Court justices. In 1801, when the capital was being moved to Washington, D.C., the planners didn't include a place for the Supreme Court. There was no place for the Supreme Court. The Supreme Court met basically in kind of a basement office of the Senate. So, the weakest branch? I don't know. When we started our study of the three branches of government, of the legislative, the executive, and now the judicial branch, I told you that the founders believed that the legislative branch, that Congress, would be the most important or the most powerful. So for your third assignment, what I want you to think about is which branch of government do you think is the most powerful, the most important now, today? Which branch do you think is the most important or most powerful? So this is something to think about as you're watching the rest of this video.
Yeah! Woo. I was so hungry. I was just waiting for my clap.
I know. Nice.
So as I mentioned, when the Congress passed the Judiciary Act of 1789, they actually created a whole court system. Okay, so, and as you can see from this list up here, basically what we have are 51 separate court systems. And then remember, this goes back to the issue of federalism that we talked about a while ago. So we have 50 state court systems, and then we have one federal court system. What we're looking at now is the federal court system. This is our focus. And basically what you can see over here is that the federal judiciary has three levels. Okay, there are district courts, and there are 94 of those courts throughout the country. These courts are based on population. There's at least one in each state. New York happens to have 4 because we have a very populous state. These district courts are divided into trial courts. They're either criminal or civil courts. Criminal courts is when a law is broken. Civil courts is when an individual, a group, or an entity has been wronged. Okay? The second level that we have are courts of appeals. And here also, again, they're divided throughout the country. There are 13 courts of appeals. In the courts of appeals, there are no juries. There are basically 3 judges who decide the case. And what they're looking at in a court of appeal is they're looking at legal questions that have arisen from these district courts, from the criminal and civil courts. They're looking at, was the procedure, were the laws followed correctly, okay? And then finally, the final level of the federal court system, sort of the top tier, if you will, is the Supreme Court. And basically there is only one Supreme Court. This is the ultimate or the final appeals court. There are 9 justices who decide the cases in the Supreme Court. And almost all the cases are heard on appeal. So these are cases that have made their way up through the criminal justice system and then finally arrive at this highest level of the court system. Now, we're going to focus most of our attention right now on the Supreme Court. And as I said, the Supreme Court has 9 justices, okay? The justices are nominated by the president, and we talked about this in the last video when the powers of the presidency. So they're nominated or chosen by the president. But that's not the end of it. That nomination then has to go to the Senate to be approved or confirmed, right? So this is an important step. And what we see is that although it's not explicitly spelled out in the Constitution, that the Supreme Court has developed what we now call this power of judicial review. Okay, judicial review. And this is probably the most important thing that we see the Supreme Court doing. If you look, this is on page 286 in your textbook. Judicial review is the power of the courts to review and, if necessary, declare an action of the legislature or the executive branch invalid or unconstitutional, right? So they're basically reviewing the decisions, the actions of the legislative branch and of the executive branch. Okay? Judicial review. So we're still thinking about this question that Hamilton raises about the judicial branch being the weakest or the least powerful branch. Now, another thing I want to think about is that representatives serve for a 2-year term, right? Re-elected every 2 years. Senators serve for a 6-year term. Representatives and senators have no term limits. They can be elected over and over again. The president, the executive, serves a 4-year term. And he has or she has a two-term limit, right? So the president can serve for a total of 8 years. So that's the legislative and the executive branch. When we come to the Supreme Court, and the Supreme Court justices in particular, they serve for life. They serve for life. Okay? And just to give you a sense of this, Chief Justice Roberts has been serving for 14 years, Ruth Bader Ginsburg for 26 years, Justice Thomas, 29 years, Justice Breyer, 25 years, Justice Alito for 13 years, Justice Sotomayor, 10 years, Justice Kagan for 9 years, Justice Gorsuch for 2 years, and Kavanaugh for 1 year. Okay? It's a long time. These people serve for a long time. They serve for life. So these 9 people, these 9 justices, have the authority to declare laws or actions of the government unconstitutional. The Supreme Court sets its own agenda. There is no right to a Supreme Court hearing. Okay? Basically, what we have in the Supreme Court is what we call the rule of 4. And that means that 4 of the 9 justices need to agree that your petition, that your case is in fact worthy of a hearing. Okay? Now the Supreme Court receives approximately 8,000 petitions in the course of a year. 8,000. They couldn't possibly hear all of those petitions. Last year, well really in this year, 2019 through 2020, they've agreed to hear or to receive 75 petitions. 75 out of about 8,000 in this session, which lasts from October in 2019 through June 2020. So that is an awful lot of petitions that they do not hear, right? And this is an incredibly powerful thing that the Supreme Court is able to basically decide which cases they're going to take on, and therefore which rulings they will make, right? And so as you see, when we talk about some particular cases, the fact that they chose to rule on these particular issues, this is incredibly significant. So these 9 people can have a profound impact on our American political system. And what I want to do is I just want to look briefly at a few landmark decisions that the Supreme Court has made throughout the years that have basically changed the course of American history. The first one that I want to look at is Plessy versus Ferguson, 1896, Plessy versus Ferguson. In the ruling in Plessy versus Ferguson, the Supreme Court said that essentially racially segregated facilities were in fact constitutional. They were in keeping with the Constitution as long as the facilities were equal, as long as they were equal. The background on this case is simple, that Homer Plessy, a black man who he was actually 1/8 black, boarded a train that was labeled whites only. Okay? He boarded this train intentionally in order to challenge the Jim Crow segregation laws of the time. He was arrested, he was removed from the train, and he challenged this conviction, right? And what we see is that his case goes all the way through the court system up into the Supreme Court. And what we see is that the Supreme Court basically sided with the train company, saying, no, Plessy did not belong on that whites-only car. Why? Because there was a car that was for black people, and he could go on that car, right? And essentially what we see is a doctrine that we now think of as the separate but equal doctrine was set in place by this 1896 decision. And what this decision and what most Supreme Court decisions do is they set what we call a precedent. A precedent. It's a rule that tends to guide other court decisions. Okay, and so what we see in 1896 is that a Supreme Court decision basically says that Jim Crow laws are legal and acceptable within the guise of the Constitution. Even though we have the 14th Amendment, which requires equal protection under the law, they interpreted that amendment to say that as long as facilities were equal, it was okay to have separate facilities. Okay, so fast forward to 1954. And basically what we see in this Supreme Court decision is that the separate but equal doctrine is overturned, right? And a new precedent is set. So we get rid of this one and we have a new precedent. And what happened is basically the Supreme Court looked at the situation of a third grader, Linda Brown. Her family, Linda Brown was black. Her family was challenging the notion that they had to send their daughter across town to the black school instead of around the corner to the white school. The court looked at this situation and said, separate is not equal. That basically separate is inherently unequal. And the fact that you are setting up separate institutions means that they are unequal. And basically what we see is that with this decision in 1954, like I said, this precedent was wiped out, and what we have is the foundation for integration of our public schools. Now, obviously this decision does not solve all the issues, and we still have racial segregation in our schools and in other institutions in our society, but it certainly does lay the foundation for the change. Okay? Forging ahead, we see in 1963 another incredibly important landmark case, Gideon v. Wainwright. In this case, what we see is that there's a man, Clarence Earl Gideon, who is accused of a burglary of a pool hall in Panama City, Florida. Now this burglary happens. Later in the day, somebody said, hey, I saw Clarence Earl Gideon near there. He's arrested. He is brought into court, and he says in the course of his trial, he said, I would like a lawyer, but he didn't have money to pay for a lawyer, and so his request for legal counsel was denied. And he was convicted and he was sentenced to 5 years in prison. While he was in prison, Clarence Earl Gideon actually used the library in the prison to study law, and he made a petition directly to the Supreme Court in which he challenges his conviction because he said his Sixth Amendment right to counsel was denied. And in fact, the court finds in favor of Clarence Earl Gideon, and Justice Hugo Black says, and I quote, lawyers in criminal courts are necessities, not luxuries. Lawyers are necessities, not luxuries. And what we see as the result of this Supreme Court decision is that basically our criminal justice system is reshaped, and that people, regardless of their ability to pay, are provided with legal counsel during a court proceeding. Pretty incredible, right? All right, moving forward, we see another court case, Roe v. Wade, 1973. In Roe v. Wade, basically what we see, the Supreme Court decision rules that women have a constitutional right to choose whether they would want to have an abortion. Women have a constitutional right to choose whether they want to have an abortion without excessive government intervention or restriction. Now, I mentioned earlier that the founders designed the Supreme Court so that the justices would be able to sort of stand apart from the politics of the day. When we think about the issue of abortion, even today, that was in 1973 that decision was made, but even today, still today, the issue of abortion is obviously political. It is incredibly controversial, it is incredibly painful, and so we see that public opinion definitely looms large when the justices are making decisions about this issue, even today. More recently, in 2008, we see the court case of District of Columbia v. Heller, okay? This is a court case where the court is looking at an interpretation of the Second Amendment, the right to bear arms. And basically what the court decides is that citizens do, in fact, have a right to possess firearms at home for self-defense, right? We have a right to possess firearms at home for self-defense. Now I want you to notice in the lower right-hand corner of this photo that you see NRA. And if you remember, we actually talked about the NRA earlier on in some of our assignments, and we looked at the National Rifle Association. This is an interest group that supports the Second Amendment and rejects many efforts at gun control. Okay? And obviously they were extremely happy that with this Supreme Court decision. All right, so the last case I want to look at is 2015 Obergefell versus Hodges. In this case, the Supreme Court ruled that the fundamental right to marriage is guaranteed to same-sex couples. The fundamental right to marriage is guaranteed to same-sex couples. It's guaranteed across all 50 states. Okay? Obviously has a profound impact in terms of the way people live their lives. So you see, these are just a few cases, but you can see that Supreme Court decisions have an incredibly important effect on civil rights, on civil liberties, on interpretation of the Bill of Rights, on very personal decisions like abortion and marriage. And the court today, at this very moment, the court today is addressing cases regarding free speech, regarding immigration, particularly with the case of the DACA program. Should it be revoked or should it be continued? Things in terms of religious liberty, just to name a few of the issues that literally this week the court has been dealing with. Now, as you can see from these decisions and many others, that the decisions that the Supreme Court makes have radically reshaped American society. Radically reshaped American society. These decisions stand, they're precedents, until a new ruling is made. So maybe, I don't know, maybe you're thinking, wow, the Supreme Court is in fact the most powerful branch. That's what I'm going to write about. Maybe. But let me remind you that the Supreme Court makes these decisions, but they are only 9 people. We have 9 Supreme Court justices. Somebody else has to implement these decisions. Somebody else has to make these things happen. We see Brown versus Board of Education says that you cannot have separate but equal schools. You cannot have segregated schools. Look around you. Look around you. Most of us probably can think of schools which are not well integrated, right? And that has to do with the way in which these things are implemented. So it's one thing for the Supreme Court to make a decision. It's another thing for these decisions to actually be enacted in society. And this is just one example. Any of these things, we could talk about the way in which they are implemented, which is not necessarily always the most effective. So it takes people to make them happen. The people that make these things happen are either the executive branch or the legislative branch. So which branch do you think is the most powerful? Which branch do you think is the strongest branch of government? Would you say that the Congress is the strongest branch of government, the one that's responsible for lawmaking, responsible for oversight, especially now when we're talking about trillions of dollars going out to the American public? Do you think about the executive branch, the president, as being the most powerful? The president is the commander-in-chief of the military. The president is the head of state. The president is the chief executive and the chief diplomat. Or do you think that the judicial branch, these people who serve for life, so we see them serving for 30, sometimes 40 years, incredibly important decisions changing the course of American history, is this the most powerful branch? I will look forward to reading your responses to this question.